Looks like we have a great turnout, so I appreciate everybody who's joining today. My name is Luke Fry. I'm the Associate Director of Communication for the Better Business Bureau here in Connecticut, and we are excited to take this next look into the CT paid leave program. So Erin, we appreciate having you here today to kind of walk us through all of those legal type questions we all have about the program, all the differences, yes, so I'm just gonna let Erin take over, and thank you again for joining us today.
Thank you so much for inviting me. I'm going to go ahead and share my screen so I can pull up the slide deck and try and get back to the beginning here. Hold on.
We can see your screen, Erin.
Okay, great, thank you. So I'm going to go through the slides. It'll take usually about 25 to 30 minutes, and then we can save the remainder of the hour for questions and answers. If you have questions during the presentation, it'd be great if you could throw them into the Q&A function as opposed to the chat. If it's in the Q&A, I can keep track of them and make sure I get all of the answers in a little bit more, in a more organized fashion than doing it through the chat. So just briefly about myself, I am the General Counsel for the Connecticut Paid Leave Authority. I officially joined the authority this past fall. Prior to that, I worked at the Department of Administrative Services for 14 years in various legal and legislative functions. My background is as an employment lawyer, and I worked in private practice before coming to the state, and have been dealing with FMLA my entire professional life, including primarily training and setting the policies for the state with regard to how state employees experience FMLA. So I'm going to go through an overview of the Connecticut Paid Leave Program with some key dates, and then we're really going to dive into understanding the leave laws and how the new Connecticut Paid Leave Act fits into the existing kind of array of leave laws. We'll talk a little bit about the claims administration and the role of the employer with a couple of examples. I'll share some resources on our website, and then, as I said, we have time for some questions and answers. You'll have the questions, hopefully I'll have the answers. So let's just frame the work of the Connecticut Paid Leave Authority. We are a quasi-public agency. We're created by Public Act 19-25, and under the Connecticut Paid Leave Act, which was created and passed based on a recognition of the legislature that individuals who can't work, either because they're sick themselves or they have to care for a family member who's sick, really can't afford to just go without a paycheck. It's just a huge obstacle. And so the outcomes are they lose their jobs and go on unemployment, and there are significant costs with that route, or they sort of try and muddle through doing the best they can, trying to go to work, trying to take care of themselves, and really kind of nobody's getting a good bargain out of that. So the idea behind the Connecticut Paid Leave Authority is to give employees a way of actually accessing that job protected time off by ensuring that they have some income replacement while they're taking leave. And it is also to ensure that employers, third-party administrators, and healthcare providers understand their roles and responsibilities. And we feel it's our job to help them navigate this system as well as the employees. Statutorily, we're required to engage in outreach and engagement, which is why we love opportunities to join with the Better Business Bureau and other entities to really get the word out and make sure we hear what employers and employees need, and so that we can help them understand what they have to do. We also have to run the agency, right? So we're busy developing policies and procedures needed to run the program. We're required to establish the contribution rate. It cannot be any higher than 0.5%, but in the future, if the fund is solvent and in good shape, we may be able to reduce that contribution rate. And we also have to receive contributions. There is an opportunity in the statute for employers to fulfill their obligation under the plan by applying to the authority for permission to offer a private plan that has to have all the same benefits and same protections as the state program. And so we have a responsibility to review those applications. And if we approve the plan, we have to audit those private plans to make sure that the employees are getting the benefit of that bargain. And then we'll be administering claims for leave benefits, which is highlighted here because that's really where we're going to focus most of our attention today. I do want to remind everyone that the obligation to start taking the contributions began on January 1st, 2021, so just a month ago. You remit the contributions at the end of the quarter, but you have to take the contributions now. So, threshold question, who is covered by this law? And the answer is most every employer. There are some exceptions, but primarily, if you have one or more employees working in Connecticut, you are a covered employer, and that includes nonprofits. It includes private sector employers with a unionized workforce. It includes small businesses. So if you have employees, you're covered, unless you are the federal government, the state of Connecticut, or a municipality or a local or regional board are excluded except to the extent that they have covered public employees, which I'll define in a moment. Non-public elementary and secondary schools are also excluded. There are certain federal statutes which provide other exclusions, such as railroad workers are subject to a federal program, and so they're not participating in our program. There are a couple other federal statutes that implicate or are implicated by our law. But unless you're in one of those areas, you really are covered. Sole proprietors and self-employed individuals. So we're talking about people who are not receiving W-2s, right? They're people who are self-employed. They don't pay themselves as employees. They don't receive W-2. They pay self-employment taxes. Those individuals have the opportunity to opt in if they choose to. If they choose to opt in, they will make contributions, and they have to stay in the program for at least 3 years. Okay, so those covered public employees that I mentioned. If you're a covered public employee, you participate in the program, you make the contributions, and you will be able to apply for benefits. So all non-unionized employees of the state of Connecticut are covered, so we are contributing. Unionized employees of the state who collectively bargain to be included could become covered if they choose to do so through collective bargaining. Employees of municipalities and local and regional boards of education are currently out, but if their unionized employees collectively bargain to be included, then everybody in that municipality or everyone who works for that board of education will be included. We do get a lot of questions from sole proprietors who think that they have to participate. So I just want to be really clear. If you are a sole proprietor or self-employed individual, you're not an employee of your organization, but you're truly self-employed, you do not have to participate, but you can if you choose to. And their contribution rate is based on their subject earnings, which is defined by their self-employment taxes as opposed to their payroll taxes. So as I mentioned, one of our responsibilities is to manage the contributions. So the program is entirely employee funded, meaning that the money comes from the employees. The employer handles the payroll though, so the employer is responsible for remitting the employee contributions to the paid leave authority. We ask for minimal wage information. We really don't want it to be too much of a burden, but we do need some wage information to make sure we're getting the right amount for the contributions. That money comes into the Connecticut Paid Leave Authority and is immediately deposited in a paid leave trust. This is a protected account. It can only be used to administer the program and fund the benefits. It's overseen by the Office of the Treasurer, but it is not a state fund. It cannot be used for any purposes elsewhere in state government. It can only be used for this fund. The contributions are post-tax, And the way you figure out the contributions is you calculate your employees' wages the same way that you calculate them right now for purposes of FICA. Basically, that means that you don't have to impute the value of cafeteria plans or other employee benefits. So you figure out what their wages are, same way you calculate it for FICA, and then you take the 0.5%. Because the contributions are post-tax, you can't use the contribution to lower the employees' payroll taxes. The contributions are capped at the Social Security contribution limit, which is currently $142,400. Okay, as I said, we do have this private plan option, which is where if the employer says, you know what, I'd rather have everything under my own control. So I will offer my employees the same or better benefits as the public plan. I'm not going to charge my employees anything more than the 0.5%. I can charge less, but I can't charge more. And I will use that money to administer that private plan. The employees have to vote on this. It can't be done just at the employer's discretion. Because the program is entirely employee funded, the employees have the final say if they want to be in the public program or the private plan. If the employer has gone through all these steps, they can apply to the Paid Leave Authority for approval for their private plan. If they get approval, they do not have to remit contributions to the authority. We're going to talk about this later, but right now, if you haven't registered with the Connecticut Paid Leave Authority, we need you to register as soon as possible so you can set up your account and be ready for the contribution remittance at the end of the quarter. Once you've registered, you can also go through that same account to submit your application for a private plan. That is now functional. All right, just a couple of key dates. All right, we've got a little spacing issue here. Registration opened in November. We have over 43,000 employers who have already registered, I think, but we know that there are a lot of employers who haven't registered yet, so we really need you to register. The purpose of registering is to get yourselves up and running, right? To create your account, to make sure you know how to get to your account so that when you remit your contributions at the end of the quarter, it's a simple and straightforward process. We also want employers to register so that we know that they know that they're supposed to be taking the contributions because the contribution obligation began on January 1st. As I mentioned, the application function for private plans is open. Employers can start submitting those plans to us and we'll review them. If you want a private plan, you have to have the application submitted and approved before the end of March in order to not have to submit contributions. Now, technically, the contributions are due at the end of the quarter, but we were asked and we agreed that we wanted to keep on the same process that or timing that DRS and DOL do, and those agencies allow employers a 1-month grace period after the end of the quarter to submit their payments. So we're doing the same. So as long as you get it in by 1 month after the end of the quarter, you've filed your contributions on time. And we're just moving straight forward into claims administration. By December, we need to have our claims administration functionality up and running so that employees and those self-employed individuals and sole proprietors who have voluntarily opted in can start submitting for benefits. They can submit their application before January 1st, but we can't pay anything until after January 1st. But we know that certain people will know what's going on ahead of time. We want to get those applications in early. And then we can start making benefit payments as of January 1st, 2022. Okay, so that's all the things we're doing behind the scenes to make sure that the system is going to be up and running, and that's the timeframes. But the request for today was really to talk more about sort of the legal implications. So that's what we're going to focus on for this next little bit. As I said, the Connecticut Paid Leave Act was created in 2019 to take effect, well, the contributions take effect in January. The ability to receive benefits will take effect on January 1st, 2022. but it's not a brand new concept. It fits into this existing framework of other leave laws. First among them is the federal FMLA, which applies to employers with 50 or more employees. We also have a Connecticut FMLA, 31-51KK, if you're interested. That's been on the books since 1996. And right now, and for the last couple of decades, it's applied to employers with 75 or more employees. But effective January 1st, 2022, it will apply to employers with 1 or more employees. We'll talk about the changes in more detail in just a moment. But I also want to point out to everyone that leave laws, or the right to take leave, also are part of the workers' compensation statutes, the Americans with Disabilities Act, the Pregnancy with Disability Act, and the Connecticut Fair Employment Practices Act. So if you had 15 or more employees, you're subject to the ADA and the PDA. And if you have 3 or more employees, you've been subject to the CFEPA, or Connecticut Fair Employment Practices Act. And under all 3 of those laws, job protected leave might be a reasonable accommodation for an employee who has a serious illness. So we've had a lot of job protection on the books. We haven't really had income replacement. You can get income replacement through employer policies. You can get workers' comp benefits for covered on the job injuries, but we haven't had a law until now that allows employees to receive some income replacement while they're out of work. And that's the gap that Connecticut Paid Leave Act fills. So when can you take leave and when can you receive income replacement benefits? Well, under federal FMLA, Connecticut FMLA, and the Connecticut Paid Leave Act, these are the reasons you can take leave: to expand or create a family with a new baby, or to adopt or take a child in through foster care. This is called bonding leave. You can care for a family member who has a serious health condition, which is usually called caregiver leave. You can, of course, take it for your own serious health condition. And I just want to flag that in addition to illnesses that you might normally think of, like person broke their leg or had cancer, serious health condition also includes serving as an organ or bone marrow donor and pregnancy. There are 2 types of military family leave. One is called military caregiver leave, and that is time away from work to care for a family member who's been injured in active duty. The other is called qualifying exigency leave, and that's available when a family member is called to overseas active duty. And that law allows you to take time away from work to attend specific things, like going to a farewell ceremony, sending off ceremony, or to update your legal and financial arrangements. So there's a list of specific reasons that qualify. In addition to Connecticut FMLA and federal FMLA, Connecticut law has something called the family violence leave, which has been, which I think was enacted in 2012. And that allows an individual who's impacted by family violence to take job protection time away from work, it's 12 days, to seek care or counseling, to go to court, or to relocate. And you can receive income replacement through the Connecticut Paid Leave Act for that family violence leave. So I've told you that the reasons for leave between federal FMLA and Connecticut FMLA are very similar. There's one big difference, and that is the definition of family member. When we're talking about federal FMLA and the standard reasons, the military family leave has different definitions that I can get into if you like, but they're not used that often. But for the standard FMLA, bonding, caregiver, your own health condition, a family is your parent, your spouse, or a child who is under 18 or is over 18 and has a disability. For Connecticut FMLA and for the Connecticut Paid Leave, you can take leave to care for a parent, a spouse, a son or daughter of any age, as well as a sibling, grandparent, grandchild, or an individual who's related to the employee by a close association as opposed to by blood or marriage. So what does this mean, this close association or affinity? That is a term that we haven't really seen in Connecticut before, but it's something that the federal government has used for several decades in connection with It's federal contractor sick leave and bereavement leave and a few other things. And basically, it's a situation where you've got a chosen family, a non-traditional family perhaps, or just a different, it's not Ozzie and Harriet Nelson, right? It is, it could include your great aunt who, you know, you went grocery shopping for and who came to every family celebration and who you were responsible for making sure that when she broke her hip, you were the one who took her to the hospital and got her situated. That great aunt could be equivalent to a grandparent. And so the family member or your employee could take leave for that person. It could be individuals who are not married but share a household and treat and have a relationship, sort of the Goldie Hawn situation with her husband, not husband, longtime partner, whose name I'm forgetting, Kurt Russell. That would be a affinity family relationship. Okay, couple of just simple, basic, like if you just need to know everything you need to know in one slide, we've tried to put that here for you. And one big question is, how long do you get leave? For federal FMLA, it's 12 weeks in a 12-month period, except that military caregiver is a one-time leave entitlement of 26 weeks. For Connecticut FMLA, once the law changes in 2022, it will be 12 weeks in a 12-month period, except that you still get 26 weeks in a 12-month period for the military caregiver. And as I noted, there's that 12 days for family violence. And there's also going to be a right to take, or at least an opportunity to take 2 additional weeks of leave, so to get a total of 14 weeks if you have an incapacity due to pregnancy. Now, this is a change. Under existing Connecticut FMLA, you get 16 weeks in a 2-year period. So the law as of 2022 will now apply to, or now allow for 12 weeks in a 12-month period. So it's a little bit more akin to the federal, with the exception of that 2 additional weeks for pregnancy. Connecticut paid leave allows an in-person to receive paid leave benefits for up to 12 weeks in a 12-month period. And that includes leave associated with military caregiver leave. As I mentioned, we also allow you to use 12 days to receive income replacement if you need time off for family violence. And we also have that additional 2 weeks for incapacity due to pregnancy. Eligibility requirements is another big area of change. Just for background, federal FMLA says that you need to be employed by the employer for at least 12 months, and you have to work at least 1,250 hours in the 12 months immediately preceding leave. Under the Connecticut FMLA, as it stands right now, you also would have to show you worked for 12 months and that you worked for at least 1,000 hours. But as of January 1st, 2022, that is changed. And in 2022, an employee will be eligible for job protected leave as long as they've been employed by the employer for at least 3 months. And there's no hours worked requirement. That's for job protected leave. In order to be eligible for income replacement benefits from the Connecticut Paid Leave Authority, the employee has to show that they've earned at least $2,325 in their highest earning quarter. To determine their highest earning quarter, we're going to look at the first 4 of the most recent 5 quarters. To determine if they've earned that $2,325, we'll look at their, I apologize, my dog has found me. We will look at all of their employment. So if they have multiple jobs, we'll look at their earnings from all of their employers. In addition to earning that money, they have to show us that they are currently employed in Connecticut, or that they had been employed in Connecticut within the past 12 weeks before they asked for the income replacement. As we've mentioned, a sole proprietor or self-employed individual who's voluntarily chosen to opt into the program and meets the 2325 will also be able to apply for income replacement. Okay, so how does this all work? Well, employee has or knows that they are about to have one of those qualifying reasons for leave. They're about to adopt a baby or child. They're know that they need hip replacement. For job protection, they're going to talk to their employer. That doesn't change. But for income replacement, they're going to come to the paid leave authority and apply for benefits. We will validate if they're eligible by looking at their earnings and validate that the reason that they're asking for leave is a covered reason and that they have documentation to support it. We calculate the employee's benefit amount, but the benefit is offset by any employer provided paid time off. So we will communicate with the employee and the employer to determine if there are any offsets. We also need to validate the employee's actual covered absences. And then we will issue the benefit payments while the employee is out. The benefit payment is dependent upon how much the employee earns. The statute sets out a two-part calculation. If the employee earns less than or equal to the Connecticut minimum wage multiplied by 40, their benefit will be 95% of their wages. If they earn more than the Connecticut minimum wage multiplied by 40, they'll get 95% of that wage plus 60% of the amount that their earnings exceed the Connecticut minimum wage times 40. However, in all situations, the total weekly benefit is capped at 60 times the Connecticut minimum wage. So just a couple of scenarios here to kind of explain how it works and more clear. To make my life easier for math, I just fast forwarded us to the time when the Connecticut minimum wage is $15 an hour. So that makes for nice round numbers. So 40 times 15 is 600. 60 times 15 is 900. So in scenario one, Lee is earning $500 a week. That's less than 40 times $15. So Lee's weekly benefit will be 95% of 500. Alex, on the other hand, earns $1,000 a week. So we'll do the 95 times 600, which is the base, plus 60% of the difference between what Alex earns and the 40 times the minimum wage. So in that situation, you do the math, it equals to $810. That's less than 60 times the Connecticut minimum wage. So Alex's weekly benefit will be $810. The third scenario shows what happens with a high income earner. So Riley earns $1,250 a week. When you do the math, you see that that would equal out to $960. But because the statute caps the benefits at 60 times minimum wage, the Riley's weekly benefits will be 60 times the minimum wage. Okay, what do employers do in all of this? Well, if you're already used to dealing with leave requests, it's going to be relatively similar. You just have another statute to consider. If you've never dealt with FMLA before, this may be new for you. But in either situation, the basic job of the employer is to ask these two questions anytime an employee asks for time off from work due to a potentially FMLA qualifying reason. Their own illness, bonding, caregiver, qualifying exigency, family violence. Is the employee eligible for job protected leave under one or more statutes? And is the employee eligible for any income replacement while they're on leave? So to break it down, is the employee eligible for federal FMLA? Well, if I'm the employer, do I have more than 50 employees? Has this employee worked for me for at least a year? And have they worked at least 1,250 hours in this past 12 months? Is this a covered reason under federal FMLA? And have they already used their entire leave allotment? Same questions for the state FMLA, except is it one or more employees? Have they worked for us for 3 months? Are they eligible for any other job protection? At least I need to consider, is leave a reasonable accommodation under the ADA or CFPA? An employee could be eligible for federal FMLA only, state leave only. They could be eligible for federal and state FMLA, in which case the leaves would run concurrently. They'd draw down on their entitlement at the same time. If they're eligible for federal and state FMLA, you could treat that leave as the reasonable accommodation owed under ADA. But maybe they're not eligible for federal or state FMLA. You still have to consider if the leave might be a reasonable accommodation under the ADA or CFPA or PDA. It may be that an employee is not eligible for any job protected leave at all. It may be that the reason for leave is not something where you can get ADA leave and they haven't worked for you for 3 months. They have no job protection, but they might still be eligible for income replacement from the authority. So when we're figuring out income replacement, the very first thing the employer has to do is determine, is this covered by workers' comp? If this is a workers' comp absence, you just follow your regular workers' comp process. An employee who's receiving workers' comp benefits cannot get benefits from the leave authority. If they're not a workers' comp situation, there's 2 more questions to ask. One is, are they eligible for any income replacement benefits from the employer? What are my sick leave policies? What's my vacation leave policy? Do I have, I don't know, comp time, maternity leave, whatever? What do I as an employer offer? Is the employee eligible for any of that? What do they have on the books? The other question is the employee eligible for benefits from the paid leave authority? As the employer, you can't answer that question. Your job is simply to tell the employee, hey, you might want to look at the paid leave authority. You might ask them if you're eligible for benefits. Why don't you go over and talk to them? Here's the link. So, as I said, you notify your employee if they're eligible for benefits associated with your own accruals, your own paid time off. The paid family leave law does not require the employer to make any changes to your existing policies, with one big exception. You must allow an employee to hold on to 2 weeks of paid time off. You can require them to use their sick time or paid time while they're taking FMLA or federal FMLA. That's the existing law. But as of 2022, you can say, I'm requiring you to use all of your time with the exception of 2 weeks of PTO, which the state has said I have to let you keep and not require you to use for this purpose. When this law was being passed, there was a lot of talk at the Capitol about, families who save for 2 years for that trip to Disney, and they're supposed to go to Disney in August, and they have their vacation time saved for that trip to Disney in August, and they break their leg in March. We want them to be able to take that trip to Disney in August, essentially. So you notify your employees what your policies are, whether they're going to be required to use the accruals, and hey, why don't you go talk to paid leave authority if you see if you're eligible for income replacement benefits. You don't make that determination about income replacement benefits from the authority unless you have a private plan. If you have a private plan, you've said, hey, I'm not sending my employees to the authority. I'm not sending any contributions to the authority. We're handling it all in-house, in which case you would determine if they're eligible for benefits under that private plan. An employee can receive benefits from both the authority and the employer as long as the total amount does not exceed 100% of their wages. And that's why we need to coordinate with you. We know that a lot of employers offer short-term and long-term disability. We have to look at the terms of that policy itself to see which comes first. But we know that most policies usually say that employees have to exhaust other sources of benefits. If you have a policy that says that, your employee would come to the insurance paid leave authority before applying for benefits through that short-term policy. So just a couple of quick examples. I know I'm running a little bit long, but I want to hit those questions. But I think it's helpful to see these and actually visually see them. So here we've got Acme Industries, which has 100 employees, and Wiley has been working for Acme for 10 years and has 4 weeks of sick leave and 2 weeks of vacation when he hurts his hands and needs to be out of work for 8 weeks. It's non-work related, which is important because the employer has to ask, is the Wiley eligible for job protection? And is the employee eligible for income replacement? So we know he's eligible for Connecticut FMLA because he's worked for longer than 3 months. We're going to make the assumption that since he's worked there for 10 years and it's 100 employees, he's eligible for federal FMLA. We're assuming he's worked the 1250 hours. We're also going to assume that he's earned the requisite amount of money, the $2,325, to be eligible for Connecticut paid leave benefits. So Wiley calls you up on Monday morning and says, I was fooling around with fireworks. I hurt my hands. I can't come to work. I'm out for the next 8 weeks. February 1st is the first day of leave. He counts down his federal FMLA and state leave as of that date, and that pulls down 8 out of his 12 weeks of job protected leave entitlement. ACME requires its employees to use their employer provided accruals first. This does help prevent stacking of leaves, so you have control over when the employee comes back and sort of gives the employer more control. And so Wiley will use his 4 weeks of sick leave. He has the right to hold on to his 2 weeks of vacation. So he's going to apply to the paid leave authority starting in March. And so his last 4 weeks of job protected leave will be paid through income replacement benefits from the authority. Another example, smaller employer, it only has 20 employees. Jamie is a part-time employee, so her work week is 3 days a week. She breaks her leg and is going to be out of work for several weeks. Because it's a smaller employer, federal FMLA does not apply, but she is eligible for Connecticut FMLA. So first day she's out, all the way through until she has the, I think it's 12 weeks. I don't remember what I put on the screen. She'll use her sick leave accruals, and she'll use 1 of her 3 weeks of vacation. And then she'll come to the paid leave authority to receive income replacement for the remainder of her time away from work. There are some specific rules that relate to spouses who work for the same employer. Under federal law, they have to share their 12 weeks if it's to bond or to care for a parent with a serious health condition. Under Connecticut FMLA, they share for bonding or to care for any family member. But under the Connecticut paid leave law, they do not have to share their entitlement to receive income replacement. Okay, before I go to questions, I just want to give you a couple of useful resources. The first is our website, ctpaidleave.org. We have tons of information on this website. We've got a tab specifically for employers, and on that employer tab, you can find all sorts of useful information like the employee rights poster in English and in Spanish, in color and in black and white, a smaller rack card that you could hand out or issue through a PDF to email. We have a mailer that you could put in with your paychecks or just send out as an email. We have a toolkit, and we also have FAQs. So we wanted to give you the tools you need to inform your employees about what's going on, why deductions are being taken out of their paycheck, and what their rights will be starting in 2022. There's frequently asked questions, and there's also videos on our website from the employer's perspective and employee's perspective. And if you're still looking for information that you can't find, there's a contact us button on our website, and you can submit your request through email, and we have a contact center who will respond to your inquiries. If need be, we can schedule a call to resolve it. We do not have a standing phone call-in center. That is an incredibly expensive thing to stand up, and it's not necessarily efficient. And we know that no one wants to wait on the phone for 5 hours. We've certainly experienced that. So we decided the most practical way was to do it through the email setup. Okay, if you don't remember anything else from today, these are the 4 things to remember. Register your business. If you're an employer and you haven't registered, go and register as soon as you can. It takes less than 10 minutes. We've got checklists and it's very easy to go through, but you do need to register. If you have a third-party payroll processor, you want to make sure that they are processing the withholdings. They should be. We've been working with them for 9 months, so they should all be set. If you use QuickBooks, make sure you've got the most recent version, because that was updated in December to include this withholding. And then educate your employees. Let them know what's going on. Let them know why you're taking the deductions. And then visit us. Come check out our website. Check it out. Make it a favorite, because we update it frequently. All right, I'm going to stop sharing and we can go to the questions. Amber, were you able to help me with this?
Yes, absolutely. So I've been answering some of the questions while you've been doing your presentation.
Great.
So I will start at the top and work our way down. The first question is, how do I set up my ACH payments?
Great question. I am the lawyer and I am not the financial person, but I can tell you that the answer to those questions are on job aids and checklists on ctpayleave.org. There are two ways, I can tell you generally speaking, that there are two ways that employers are going to be remitting payments. Employers that use third-party payroll providers or large employers can do it through batch processing, or you can submit it directly through our website. And I apologize for not having more detailed information, but as I said, it's on our website.
Great, thank you.
So I
Just so
see
you
a
all
question
know,
about
I did drop a link
QuickBooks.
in the chat that does have our website and our contact us portal link as well.
Great.
The next question is on QuickBooks. Do you know if QuickBooks Payroll handles both the employee contributions and remitting to the Connecticut paid leave? This person is a tax preparer, and many of their small businesses use QB for payroll. It would be a burden for them to learn and use a separate system for Connecticut paid leave.
Right. So my understanding is that QuickBooks allows you to pull the contributions, and but it's not, QuickBooks itself is not set up to actually process the contributions. So they can just go to once they set up their account at ctpayleave.org, in their My Account, there's a way to just remit the payments directly through the website. Sort of similar to the ACH question before, you can find job aids and checklists on our website. We've done a lot of user testing and really tried to make it as simple as possible.
Great, thank you, Erin. All right, our next question is, how do you know if you will have time to do a private plan? Right now, everything is handled by this person's administrator, their letters and etc. What happens if they stay with the public plan?
Yeah, so great question. So right now, what I'm assuming your administrator does is handle the job protection. So both federal FMLA and state FMLA require you to issue notices and receive med certs, and that's all about managing the job protected leave itself. That's not going to change. The private plan is about providing income replacement. So if you stay with the public program, you will continue to do the leave management the same way that you're doing it right now, and your employees will go to the Connecticut Paid Leave Authority to request income replacement. If you have a private plan, you need to take on yourself or purchase a policy that will cover that income replacement. I do want to note that a short-term disability policy is the same private plan, because a short-term disability policy does not cover all the same reasons as the law provides. There is information on the website about the private plan, the requirements for the private plan, and sort of options. If you're interested in, and I'm seeing a couple of questions popping up, if you're interested in an insurance solution as opposed to a self-insured plan, we have a list of the insurers that have been authorized by the Connecticut Insurance Department to offer a private paid FMLA plan. So at least you can start with them.
Okay, and there was actually more to that question, but I didn't want to completely bombard you. So the next portion of that question is, how would that work with the current disability plan, and what would the HR team need to do?
Right. So again, if the disability plan is short-term disability, that's sort of separate. If the disability plan is just leave management, you as HR will still handle your employees' leave, or you'll still tell your employees to go to whatever third-party administrator you have working with you to do just leave management. And then you'll send your employees to the paid leave authority to get the income replacement.
Okay. All right. If our small business chooses to keep 1/2 of 1% in a separate self-held fund that the employees have fund for self-funding only, can they choose not to contribute into the state fund?
Right. So basically, this person's asking about the private plan option, and there is a self-insurance plan option. So if you go to the website, you'll see how to apply for a private plan. And there's a document that's called the private plan policy, and that is in procedures. And that sets forth all of the requirements for both an insured policy or a self-insured policy. If you have a self-insured policy, you have to create a policy document. You can't just say, well, we've got money held aside. You actually have to create a policy document or a plan document and show that you are aware of your obligations and will pay the money. Additionally, if you're self-insured, you need to obtain a surety bond equivalent to a year's worth of contributions, so that there's some protection just to make sure your employees are protected, even if anything goes wrong.
Okay. And I'm just dropping the link to the private plan policy in the chat real quick for everyone.
Great, thank
You
you.
want to take a look at that? Okay, thank you. So is it correct to say that Connecticut paid leave replaces the current Connecticut FMLA, except now is paid in up to 12 weeks as opposed to the 16 weeks, and applies to more employers versus the 75 employee rule?
No, it's not. So there are two separate statutes. Connecticut Paid Leave Act is actually found at 31-49E, and the Connecticut FMLA is found at 31-51 KK. So they're related, but they're still separate. And so Connecticut FMLA will change in 2022. It will be 12 weeks, and it will be the one or more employee, 3 months. So that's for job protection. And then the Connecticut paid leave really just applies to the income replacement. So you're going to have two laws instead of one.
Thank you, Erin. Okay. Will the authority rely on the employer's eligibility for leave to determine the period of time income replacement is to be provided? Will the employees provide detailed medical information to the authority to help support their claim?
Can you say that again? Because I'm not seeing
Sure.
that question, and I'm having trouble understanding what you're saying.
Will the authority rely on the employer's eligibility for leave to determine the period of time income replacement is to be provided? That's the first portion
No.
of the question.
Right. So no, they can't, because the eligibility requirements for job protection are different than the eligibility requirements for income replacement. So we will be asking for similar information, right? So just like right now, the employer asks for a medical certification to substantiate the need for leave, we'll be asking for that same med cert. So we'll be getting the same documentation. Because the eligibility standards are different, we can't rely on the employer's decision.
Okay, and the second portion of the question is, will the employee provide detailed medical information to the authority to support their claim?
Yeah, we're going to get the medical information from the employee so that we can make a determination that it's a qualifying reason.
Okay, great. Thank you, Erin. The next question we have is it correct say that the Connecticut paid, oh no, I'm sorry, we answered that one. For military leave, what if someone is deployed and our employee must care for their children under the age of 18? Does that qualify?
Great question. So qualifying exigency leave has 9 reasons, and one of them is for emergency child care. It's not for regular child care. So your employee's spouse, for example, is the primary child care tender, and that spouse is now deployed. And so your employee is like, I no longer have someone at home with my kids. They can say, I need to take qualifying exigency leave to set up alternative childcare, or that alternative childcare won't be available for a week. I need to be home for the week. They can't say, my spouse always took care of the kids. Now she's deployed, so I need to stay home for the duration. It's really only meant for that transition.
Thank you. And could you touch base on the respective family with the affinity? Again,
So Department of Labor has not yet issued regulations for the Connecticut FMLA, but the Connecticut Paid Leave Authority has adopted a definition of affinity. We're actually posting our entire glossary of terms, so all of our definitions will be posted on our website. And we have worked with the Department of Labor because we want to make sure that anything we adopt is going to be similar to what they adopt. So we expect them to adopt what we've already adopted. And so you can find that on our website.
okay, great. Is the 40 multiplier because the minimum wage is an hourly figure and presumably the earnings for this leave would be paid weekly, 40 hours?
You know, I can't really give you a definitive answer about the 40 multiplier. I think it was part of the legislature's compromise in terms of trying to set up a benefit amount that was reasonable, that wouldn't go bankrupt, and to recognize that if you are on the lower end of the wage spectrum, you're using a lot more of your dollars than for just basic sustenance than someone who's earning a whole lot more. So I think it was just a compromise number. I don't think it has anything to do with the 40 hours a week.
Thank you. Is there any trigger, like complications during pregnancy, for the additional 2 weeks of income replacement during pregnancy? Or will all
Mr. Cook, I
pregnancies
see
be
this question
eligible for 14 weeks?
comes in from someone who's come to a lot of our trainings. So you're going to be able to give these trainings yourself soon. The requirement for the extra 2 weeks, it'll be based on medical need. So the employee will have to have a medical certification saying that the individual is experiencing an incapacity during pregnancy such that they need the extra time. So it'll be based purely on the medical requirements.
For the new regulations, can employees not receive more than 100% of base pay when receiving Connecticut paid leave benefits? This is a 2-part question. I'm sorry.
Yeah,
And
I'm
what
reading it
policies
as
and
you say.
benefits need to change?
So you're right. An employee cannot receive more than 100%. So the employee, it depends on the employer's policy, right? If the employer says use up our paid accruals first, PTO or whatever, then they'll use the employer's PTO first and then come to the authority. If the employer says, nope, it's up to you, you can go to the authority first, and then you can come to us to make up the difference. So if you want to make a change, you can, you're just not required to. Speaking as someone who's dealt with an FMLA for years, I do think that requiring your employees to use your employer provided time first does give the employers a lot more control and helps prevent the employee from extending their leave beyond the 12 weeks. But that's up to the employer. We will, if an employee comes to us for income replacement benefits, we will be coordinating with the employee and the employer to find out if the employer has or is providing benefits. So we will be communicating on a claims basis to make sure that we know what the offsets will be.
Thank you. The next question, our payroll provider is handling the deduction, but would they be the ones to register on our behalf, or is that the employer's responsibility?
You really need to ask your payroll provider. We know that some of the payroll providers are offering to register their employers, but we are asking for a little bit of information from the employers that the payroll providers may not have, such as who the employer wants the authority to contact when a claim comes in. So some payroll providers are saying, we're registering and we'll handle your payments, but we still want you, the employer, to go in and register so that all of that contact information is there.
Thank you, Erin. And I just saw a note, thank you, Doreen, the link that I had set in the chat did not work for the private plan policy. So I'm going to direct you all, if you look at the chat, to the page itself and scroll down to the bottom of that page, and you can find our private plan policy at the bottom of the page.
Okay, great. So I'm just going to quickly jump as you're working on that. We have a question: who handles the administrative duties such as sending paperwork to the employee? So if the employee comes to the paid leave authority for income replacement benefits, we'll deal with the employee directly and communicate with them. The employer is responsible for notifying the employee about the deductions, and you can send the those documents we've already created or modify them if you like. And obviously the job protected leave part is solely between the employee and the employer.
Okay. And this one, so I understand correctly that if the employee is eligible for paid time off through their employer with PTO or STD, state benefit will be reduced?
Yeah, again, this will depend on kind of how your policy is set up, whether the policy requires the employee to use exhaust other benefits first. But in no circumstances can an employee receive more than 100%. So it's really going to depend on what the employer's policies are and what if they have an insurance policy, what that says.
Thank you, Erin. And how does it work for an employee for bonuses and commissions as well as regular pay? Is the employee responsible to pay bonus and commissions while the employee is out for Connecticut paid leave?
The definition of pay includes those bonuses and commissions. So we'll look at we have to look at the statute sets forth what we look at for what constitutes their wages and their average weekly wage. And that takes into consideration those bonuses and commissions. So that goes into the base for calculating benefits.
Okay. And if I register with Connecticut paid leave now, will a 3-year plus tenured employee of ours be qualified to receive benefits from maternity leave?
Right. So the benefits won't be available to anybody until January 1st, 2022. So if you are an employer and you have employees, you have to register and you have to start taking the contributions now. And then starting in 2022, an employee who's in this situation has been working for you for 3 years would be eligible for job protected leave. And if they earn the 23-25 in their highest earning quarter, they could receive income replacement benefits from us if they're out of work sometime after January 1st, 2022.
Okay, thank you. The next question is in regards to, I want to say stacking. Can you collect short-term disability and paid leave at the same time?
Yeah, again, it depends on the terms of your policy. So most policies say you have to exhaust other sources of benefits first, and then you can access the benefits from that short-term disability policy. So if your policy says that, you would come to the paid leave authority and request income replacement benefits. And then once those are exhausted, you could go to your short-term disability. Alternatively, your policy could say, go somewhere else first, and we will make up the difference. And so you would come to us, get your benefits, and then turn around and say, hey, short-term disability policy carrier, I'm receiving only this much of my regular pay. please give me the difference. It really is going to be a fact specific based on your short-term disability policy.
Thank you, Erin. And I'm seeing another question, and I just want to bring it up while it's still fresh. The one that you just answered on bonuses and commissions, the attendees wanting to know, was that a yes or a no on the bonuses and commissions?
It's the employer just, the benefits will be based on their total wages. Whether an employee is eligible for bonuses or commissions while they're out on leave depends on your own policies about bonuses and commissions.
Okay, so it's essentially it's up to the employer.
It depends on what the employer's policy is.
Okay. Let's see. I'm a small business with less than 6 employees. Can my employee be covered for Connecticut paid leave for maternity leave?
Yes. Again, same answer I gave before. You know, to be a covered employer, you have to have 1 or more employees. But benefits are not available until January 1st, 2022.
All right, thank you, Erin. Let's see. So I have another question up here at the top. So not hours/pay requirement for employer to withhold and remit, but the employee is not eligible for benefits if they earn less than $2,325. If that is the case, why does the employee have to withhold if the employee is never going to use the benefit?
So the 2325, remember, is based on their earnings from multiple employers. So they may not earn enough from one employer, but many employees in that situation have multiple jobs. And so we're going to look at all of their jobs to make a determination about whether they qualify. That's the way the statute is set up.
Okay, thank you.
So I know we're at 202 to almost 203. There are still a handful of unanswered questions. So I just want to let you know, I'm happy to answer them live. I'm happy to answer them. I just want to be respectful of everyone's time. This is really more of a question for Luke and Joni.
All right, so in the meantime, I'm going to drop a link in our chat to our contact us portal. If you do have other questions, we are here to help you, and we definitely want to make sure that we do get to your questions. So please refer to the link. I've dropped it in there. I'm going to put it in there again. This is to our contact us portal. Someone from our contact center will be able to follow up with you and get you an answer to your question.
Okay.
In the meantime, I think we are good. Luke, would you like to wrap up?
Sure, yeah. If there are more
Yeah.
questions, Erin, you're more than welcome to keep answering them. But thank you to everybody who joined us today. I hope we answered a couple of your questions about the CT paid leave program. Again, thank you for joining us. You can always follow BBB on Facebook. We are going to be posting about any future webinars. We also do about the CT paid leave program on there. So please keep an eye out. And if you're an accredited business, check your emails as well. Christy is going to be emailing out any other webinars we are hosting. In the meantime, if you want to hang on and hear the other questions answered, you are more than welcome. All right. Thank you, Erin and Amber, for hosting us again, and have a great rest of your afternoon, ladies.
Great. Thank you.
Thank you, Luke. You as well.
Great. Thanks.
So I'm just going to answer the last few open questions, and then we can wish everyone good luck finishing digging out from the snow. So what should we do if we have employees who live in another state and are currently working remotely due to COVID? So we're basically following the lead of the Connecticut Department of Labor with regard to unemployment insurance. So for the question of where do I work, the answer is, where do you pay your unemployment? So if you still have employees who are working remotely temporarily, but you're still paying to Connecticut Department of Labor for unemployment, we're going to treat them as Connecticut workers. If you are paying into a different state's unemployment, we'll treat them as employees of that state. Another question is, will payroll deductions be made from the benefits? It depends. Child support is a mandate, so we would be, I think, taking the deductions for that, the same way employees can also ask for their taxes to be withheld. But other deductions that are typically payroll deductions, we would not be involved with. We have a question about letting employees opt out, and the statute was created to provide this benefit. It does not allow for an individual employee opt out. So our obligation is to administer the law as enacted by the Capitol. What are the rules around allowing an employee to retain the 2 weeks of vacation and PTO? So the statute simply says that the employer is entitled to require an employee or to allow an employee to utilize employer-provided PTO while they're out on Connecticut FMLA. And it's amended starting in 2022 to say, however, the employer must allow an employee to hold on to 2 weeks. In terms of letting an employee change their mind, I think that's going to have to be an employer policy. Typically, you would say you can't change your mind retroactively, but that's going to, the employer can't require, but it does not say that the employer has to force the employee to hold the 2 weeks. What happens if an employee doesn't have any PTO or less than 2 weeks? Then it's sort of the question is moot, right? It's just about whether the employer can require them to use existing PTO. So one question is the CT paid leave 12 weeks or 16 weeks? Just to be clear, currently Connecticut FMLA is for 16 weeks, but starting in 2022, it'll be for 12 weeks. And the Connecticut paid leave says you can get income replacement for 12 weeks. There is a question about whether the benefits are taxable, and yes, the way they wrote the statute is that the funding is post-tax and the benefits are taxable. That is just the way the statute is written, and we don't have the ability to change federal law. So that's just how we're handling it. If employee utilizes paid FMLA, does this override any at-will employment laws? If you choose to terminate their employment, will there be any penalty? So the statute says you cannot retaliate against an employee for utilizing paid leave, just like you can't retaliate against an employee for utilizing FML. So to that extent, you can't terminate for any reason, right? But that's not really different than the existing at-will law right now, which is an employee who's at will can be terminated for any reason as long as it's not an unlawful reason. So retaliation would be an unlawful reason. All right.
And the last question I see here, Erin, is will payroll deductions be made from the Connecticut Paid Leave Authority?
Yeah, I did answer that,
insurance?
which is,
Okay.
child support is a mandate, so we would have to make that. But, an employee who has deductions through their payroll for insurance would not be something that would be taken out of our payments.
Okay. Great. Thank you. And that concludes, we have one more.
So again, this is a question about the taxation. So the contributions are post-tax and the benefits would be taxed. And again, an employee can ask for us to take federal and Connecticut withholdings out of the benefits. And if they ask for that, we will do that.
All right, Erin, and it is 2:10.
All right, well, thank you very much for your interest. We continue to offer webinars on this and on how to register, and we will be offering additional training more focused on actually managing leave. We know a lot of employers are not used to doing that, so we'll be offering more training on that in the months to come. Thanks so much for having us today.
Thank you for having us. Have a great day, everyone.